Hello, and welcome to the Arbitration Conversation. So in this arbitration conversation, we're going to talk to a real leader and sort of an arbitration renegade of sorts, who's really been amazing in his work in representing individual plaintiffs in arbitration. And that is Travis Lenkner. And Travis Lenkner, he's the managing partner of his firm, Keller Lenkner LLC, which represents plaintiffs in complex litigation, including class and mass actions throughout the United States. He's represented hundreds, thousands of individual clients. He also had clerked for the United States Supreme Court as Justice Kennedy, as well as for Justice Kavanaugh when he was at the U.S. Court of Appeals for the D.C. Circuit. Travis also was the editor-in-chief of the Kansas Law Review, and I'm really pleased to have him with us and to talk about these arbitrations, because I just think it's a really interesting and important story to tell. So first of all, Travis, thank you. This is fantastic.
Thank you. Happy to be here. And you mentioned the Kansas Law Review, arbitration guru, and my law review advisor, Chris Drahosel at Kansas, is how we were introduced. And I know there's several folks, even just at KU, who have done a lot of work in the arbitration space. And it's one of the first times I learned about arbitration was in law school, and have been if hindsight is perfect, have been kind of headed this direction ever since. So glad to be here and chat. Hey,
good point about how it all sort of takes a spark,
it
right?
All works
fire burning. Yeah, absolutely. Because you have Stephen Ware as well at
That's right.
KU. You've got a good arbitration background there. So let's talk about these arbitrations. So the story, many people maybe have read about sort of the many individual arbitrations that were brought by consumers against, for example, Amazon, TurboTax, and many others. Maybe you want to just tell us about how this whole thing came about and how your law firm really, and you, became very instrumental in this story.
Sure. Well, and happy, it's certainly not just me. The entire firm has worked on these, and in particular, one of our partners, Warren Postman, who was a co-clerk of mine and of another of my partners, Ashley Keller, the Keller and Keller Lenkner. We all clerked at the Supreme Court together during the same term. And Warren joined us a couple of years ago, 3 years ago now, actually, from the U.S. Chamber of Commerce, where he had been working for defense side interests on a lot of appellate matters and amicus brief writing for them. And all of us were putting our heads together about different ways that we, with our backgrounds, could go about representing plaintiffs, particularly unconventional approaches, things that maybe hadn't been done before. And one line of cases that stood out to us was all of the work that defendants had done at the Supreme Court over many years by that point to solidify arbitration and the enforceability of arbitration clauses as something that they could use to get out of class actions and to escape liability in that context. And all of those opinions, that line of cases promises this sort of glory land of arbitration. We will all arrive at Arbitration Central, and it'll be great and efficient and informal and speedy, and it's perfect. And so, courts have relied on all of this in upholding and enforcing arbitration clauses, and in preempting a lot of state law that otherwise would have restricted arbitration. So we said, well, okay, the last step here is for some people to actually hold these companies to account under the clauses that they themselves wrote. So we've been at work, among other things we do at our firm, we've been at work in our arbitration practice, representing really now it's hundreds of thousands of clients individually against companies, both for consumer claims as well as a lot of wage and hour and employment cases that, generally speaking, would be class actions, but for the class action waiver in the arbitration clause. And so it was really born out of seeing that case law, seeing the push that defendants had made over several years, and saying, gosh, that shouldn't mean an end to liability. It should just mean that we're in a different forum, doing it a different way. And why don't we try to make that happen?
Yeah, well, it's really interesting also because, let's just take the example of the Amazon cases. It really worked to the consumer's advantage in the end. Maybe you want to speak to sort of how you brought this together, because in watching it play out, with use of the sort of consumer rules of the AAA, it really worked to the advantage of the consumers, it seems, in the way that you were able to orchestrate this. So maybe you want to explain a little bit about that.
Sure. Well, one of the groups of matters that we have at the firm is representing users of Alexa devices who were recorded by Amazon without their consent in violation of state laws in 9 states. Those states have 2-party consent requirements that make it unlawful to record a conversation unless the people on both sides of the interaction consent. So the arbitrations that we demanded, the clients we represent there, are Alexa users who signed the Amazon terms of service that included an arbitration clause, and they brought consumer claims against arbitration for those violations of their privacy. We represent a lot of those individuals against Amazon, and we ultimately filed about 75 demands on behalf of about 75,000 individuals, and we represent still more beyond that. And I can't say that we had this as a goal of the firm, but one of the outcomes in the Amazon matters is that we were notified in early May of this year that Amazon had changed its terms of service, and they are back to a very short, they went from a 350-word arbitration clause to, I think, a 2-sentence dispute resolution clause that just says venue would be great in Seattle, thank you very much, and we'll be in court, and doesn't make any mention of arbitration. So our clients' matters are still moving forward, but Amazon as a company based on that interaction with us has moved back to a traditional litigation dispute resolution clause, which is remarkable. And as I said, not something we set out to do or expected, but certainly was pretty interesting to get that email from opposing counsel with a letter saying, we direct you to our updated terms of service.
Yeah, and I wonder now, how does that work? So you said the individual arbitrations still go forward, or do they now move to a class action?
So those still go forward. There is a class action separately, but those individuals had already demanded arbitration and were underway at AAA under the old terms of service. So there's not an argument that those proceedings should stop just because the forward-going dispute clause in terms of service says something else. But conceivably, for someone who has used Alexa since that change and has not already demanded arbitration or isn't otherwise on record as having an arbitration dispute with the company, they would be in a different situation. So it's quite a development.
And I can imagine, I'm thinking about, sort of Amazon with all the costs, right, involved in defending against all these individual arbitrations. And that gets pretty expensive, doesn't it, under the consumer rules of the AAA?
It does. And, one of the things that's been so interesting about bringing these matters against not just Amazon, but all kinds of companies, is the extent to which those companies and their counsel have seemed genuinely surprised by the AAA rules and the AAA fee schedule, among other things. And I think it's just a function of companies not really having thought that anyone would do this. And the conventional wisdom was arbitration is better than class action. So possibly without even reading the AAA rules or the fee schedule, companies were moving to this regime and really just had not stopped to think about all of the consequences if someone took the approach that we did. But yes, there are initial fees, there are arbitrator costs by the hour as arbitrations move forward, there are case administration fees that the AAA or JAMS or other administrators charge. And as I said, it seems genuinely to have surprised some defendants that those numbers are even possible, but it's the contract they wrote, and all of us on our W-2s already pay for the federal courts, but that's not the case with AAA, and there are costs associated with dispute resolution, and that is one of several features of these arbitrations that is to claimants' advantage if they are coming in alongside other claimants who are themselves demanding arbitration. it has usually been the case that the defendant, not only because of filing fees, but just the sheer cost and mechanics required to arbitrate this many cases at once, is something that most defendants don't want to do or don't want to do for very long.
Right, right. And I think the point that, as you said, it is surprising, but not really, because I think about sort of these boilerplate clauses, right? And nobody really stops to look, oh, wait, you're incorporating the consumer rules. Oh, wait, the consumer rules cap the consumer costs, and it means the company is going to end up footing most of the bill. And I think that, why didn't they read the rules they put in their contract, right?
No, it has been remarkable to see how many companies have had that view, and more broadly have just had the view that when they're not in court, they can adopt a different tone. I mean, some of the defendants we've litigated against have almost gone into it believing that the arbitral forum is theirs, right? It's one that they picked. Shouldn't this be the way that it works? And frequently the answer is no, and there's an express rule on point for the issue that has arisen. But it has been really telling to see a lot of defendants and defense counsel saying and doing things with arbitrators that I know none of them would say or do with a state or federal court. And many arbitrators are retired judges, and even if they aren't, they are appointed neutrals who have quasi-judicial power in these matters, and don't take kindly to a defendant viewing it as sort of a home field advantage. And so, that's been another thing that has worked in our clients' favor. I think a lot of defendants thought that if it ever came to arbitration, it would be more manipulable, but really it only is so upon agreement of the parties. And that's the fundamental approach for being in arbitration in the first place. And where a plaintiff is the person saying, no, I don't agree. I'm the claimant here and I want to move forward, and I won't agree to put my case on pause while someone else's case is litigated, or I won't agree to an alternative schedule for X, Y, or Z. The rules govern, as you said, they're incorporated in the contract, and the parties have to go forward.
Yeah. Well, and I think it also probably helps even the playing field, because now you're talking about individuals who aren't self-represented, but they actually have the power of an attorney to speak up for them. And I'm guessing that has changed the sort of power equation that would have existed otherwise, or in many of the other circumstances when you have these sort of consumer arbitration clauses.
I think so. I mean, what we've seen is that there was a lot of, as I said before, there was a lot of selling courts on the benefits of this informal, easy, sort of pro se friendly arbitration process. And in reality, when they're challenged, companies go to one place, which is everything's litigated like a federal class action, even if it's an individual arbitration. And so, we hear from people in situations where we're not representing clients, but who they know of our practice, and they reach out, and they're just one person, and they're up against a large company in arbitration, and it's it's Gibson Dunn or some AmLaw 25 firm on the other side, just making it awful for the consumer. And definitely we have enjoyed going toe to toe, winning on discovery points and some of the things where somebody without the guidance of a lawyer would really be at sea, and relying on, frankly, the willingness of an arbitrator to invest a little bit of time to make it a fair playing field. And frequently that happens, but it's not a guarantee.
Absolutely. So do you think, as you read the tea leaves, do you think other companies will react the way Amazon did by changing their terms of service?
It's a very good question. It's one we've thought a lot about over the past several weeks. And I will say there's disagreement even internally here about what it means. Amazon was in this large dispute with a number of our clients and made the choice it made. Does it change back in a year? Does it just continue editing and revising to try to outrun liability for this or that thing? the broader question on other companies, I think the conventional wisdom in the defense bar is still very much that class actions are worse than arbitration. And there's a lot of what I think is more likely to happen first is an effort by defendants to draft arbitration clauses around what they see as the problem of quote unquote mass arbitration. And time will tell. There is even under the last decade or so of cases, there is a limit to the degree to which a clause can be written to make things difficult for a claimant. And we're already seeing some creative efforts at drafting. You have to, you, the individual person, have to show up to a pre-dispute conference without your lawyer all these different hoops to basically try to make it impossible for a firm like ours to represent a lot of people at the same time. And we'll see if those work. I think there are a number of courts, even under Concepcion and the like, that would say, look, it's one thing to say you file over here instead of over there and the filing fees are the same. It's another thing entirely to say there's a 12-step process to initiating a dispute. And if you don't satisfy that step, those 12 steps, you have nowhere to go.
Right.
So
I mean, that's highly distinguishable from Concepcion. I mean, the point of Concepcion was that they had moved so far into trying to make it as fair as humanly possible with their terms of service. So,
right.
When you kind of move around and you move away from that, and you also run into questions, for example, the AAA will not administer some of those programs. So I think you would run into those sorts of issues as well.
That's right. And we've also seen AAA be pretty strong when defendants have stonewalled, refused to pay filing fees, refused to participate, and wanted to force us into court, where we've gone when we've had to litigate motions to compel arbitration. We've seen AAA tell companies that it will no longer administer the company's dispute resolution clause based on their conduct. And so, yeah, I think that's exactly right. When someone says we adopt the AAA rules, except in the following 92 respects, it may be that they're not at AAA anymore.
Yeah, absolutely. Well, Travis, I promised I wouldn't take up too much of your time. So I just wanted this has been really interesting and just a great conversation. I know many people will watch this and really appreciate it. This is an important story about arbitration, and we're going to continue to watch as this story unfolds. So thank you so much. I really appreciate your taking time with us.
Thanks so much. Very glad to do it.